All right. Let us be on the record in case number 2021 CR 226, captioned State of Kansas versus Gary Austin. Would the parties announce their appearances, please?
May it please the court, Tonda Hill appears on behalf of the state.
And please the court, Your Honor, Mr. Austin appears from the Andrew County Jail via Zoom and with counsel Phil Crawford from another location.
All right. We are here set down for a plea hearing today. My understanding is at the conclusion of our plea that the parties will request that I waive pre-sentence investigation since this is a misdemeanor case and proceed directly to sentencing. Is that correct, Ms. Hill?
Yes, Your Honor, that is correct.
Mr. Crawford?
Yes, Your Honor.
All right. So, Mr. Austin, I'm going to take up your plea now. To do that, I'm going to have to ask you a lot of questions. If I ask you something you don't understand, tell me that, and you and I will talk about it until we're sure we're talking about the same thing. If at any time you want to talk to Mr. Crawford in private before you answer a question, you can do that. You just tell me that, and I can send you to what's called a private room so that you and he can talk without the rest of us, okay?
Yes, sir.
All right, to get started, I need to have you sworn in. So if you'd raise your right hand, my court reporter will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
All right. Mr. Austin, how far did you go in school?
All the way up to graduating high school.
All right. You read and write okay?
Yes.
All right. As you sit here today, I know you're in custody, but I have to ask, are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what you're doing?
No, sir.
All right. You feel like your mind's cleared this morning?
Yes, I do.
All right. Do you know what you're charged with?
Yes, I do.
And you know that you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on that charge or those charges. Do you understand that?
Yes, I do, sir.
All right. At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You would not have to prove anything yourself. Mr. Crawford would help you throughout that trial. He could cross-examine and confront all of the state's witnesses, call any witnesses you wanted called. At that trial, you would have a right to testify. You'd also have a right not to testify. And if you decided not to take the stand, the state couldn't use that against you. In other words, they couldn't get up and argue to the jury, you should convict Mr. Austin because he didn't tell you his side. You understand all those rights?
Yes, I do.
Right. So if we went through with that trial and at the end of it, you were convicted, you would have the right to appeal that conviction to the Kansas appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. You understand that?
Yes, sir.
All right. So if we do this plea today, you're going to be giving up all those rights. There's not going to be a trial of any kind in this case. Do you understand that?
Yes, I do.
All right. I'm going to share now what was sent to me in the way of a plea petition. I want you to take a look at it and make sure that this is the same one that you have. Let me find it here. All right. Oh, there it was. It was hiding below all the other windows I have open. All right. Can you see that document, Mr. Austin?
Yes, I do, sir.
All right. Does that look like the plea petition that Mr. Crawford went over with you?
Yes, it does.
All right. And there's a signature there down at the bottom. It's kind of faded, but it looks like your signature. Is that your signature?
Yes, sir, it is.
Okay.
Like halfway through it.
Yeah. The pen gave out?
Yeah.
Yeah. All right. So I'm going to read to you what they tell me is the plea agreement. I want to make sure that that's your understanding as well. It says that you're going to be pleading guilty to count one of the First Amendment amended information. That is a charge of criminal damage to property as a Class B misdemeanor. that the parties are going to recommend that I give you a 6-month underlying jail sentence and grant you probation for a period of 12 months. You agree to pay $371.45 in restitution, which was the replacement cost of the item damaged. Is that your understanding of the entire plea agreement?
Yeah, I understood that it was 6 months suspended jail time.
Right.
Oh, okay.
When
I see.
I grant probation, that jail time, we don't actually call it suspended because we don't have what's called suspended in position of sentence, but we call it just granting you probation. So you don't have to do that jail time unless your probation were to be revoked for some reason.
All right. Yeah, I see.
right.
Yes, sir.
Okay. Now the maximum penalty for this crime is 6 months in jail and a fine of $500. Do you understand that that's the maximum anybody can get for this crime?
Yes, sir.
All right. And although I listened very closely to the recommendations of the parties, I'm not bound by them or party to them, which means that I can give you any sentence that the law allows me to, despite any plea agreement. You understand that?
Yes, I do, sir.
All right. Do you have any questions for me at this time about anything that you and I have gone over today?
No, I do not.
Knowing all this, do you still want to go forward with this plea?
Yes, I do.
All right. Mr. Crawford, do you know any legal reason why your client should not enter a plea guilty today?
No, Your Honor.
All right. Then I'm going to ask you, Mr. Austin, as to count 1 of the amended information, which charges you with criminal damage to property, a Class B misdemeanor, how do you plead, guilty or not guilty?
Guilty, sir.
All right. I'm going to ask the state to tell me what they think the evidence would be if this case went to trial. I want you to listen closely because when they're done, I'm going to ask you if that's what happened, okay?
Yes, sir.
Ms. Hill.
Thank you, Your Honor. If this matter proceeded to trial, the state would produce evidence that on March 13th, sorry, Your Honor. Your Honor, on March 13th, 2021, officers were dispatched to a post office that was located at 135 East Cedar Street in Bonner Springs, Wyandotte County, Kansas. In regards to a report of a white male wearing a dark hoodie, black hat, and a KU face mask causing a disturbance. Specifically, there was a report that there was a damage to the glass door that had a muddy shoe print on it. When the officers arrived to the post office, employees named Mr. Gary Austin, the defendant, as a suspect because he continued to be angry with them about a disturbance of not delivering his mail. And on that day of incidents, the employees heard a loud sound of glass breaking and the defendant leaving immediately afterwards. When officers went to speak with the defendant, he matched the description of the white male suspect, including having mud on his shoes. Post Miranda, the defendant admitted to kicking the glass. Ken Welborn, Welborn, is the owner of the post office. And the door that was damaged, the defendant did that knowingly by causing damage to it through kicking it. The defendant caused that damage without Mr. Warborn's consent, and that door to replace is $371.45. Your Honor, finally, that all occurred on March 13th, 2021 in Bonner Springs, Wyandotte County, Kansas. Thank you, Your Honor.
All right. Mr. Austin, is that what happened?
Yes, sir. I let my anger get the best of me and I shouldn't have done that.
All right. All right. Well, I'm going to find the defendant has freely, voluntarily, and intelligently changed his plea from one of not guilty to guilty. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and the defendant has acknowledged that factual basis. Therefore, I will find he is in fact guilty of count 1 of the amended information charging him with criminal damage to property, Class B, non-person misdemeanor. The other charges, I don't recall if there were other charges, but if there were, they are hereby dismissed by pursuant to the plea. Parties still wish to waive pre-sentence investigation and conduct sentencing today, Ms. Hill,
Yes, Your Honor.
Mr. Crawford,
Yes, Your Honor.
All right. Then, Ms. Hill, I would ask you for your comments regarding sentencing today.
Your Honor, we'd ask that you follow the plea agreement. The only thing in additional we would ask is that there'd be no violent contact with the post office or Ken Wellborn, who is the owner of that property, and everything else that we outline with the restitution of $371.45 to Mr. Ken Wellborn, and costs and fees as this court finds appropriate.
Thank you. Mr. Crawford.
I went and talked to Mr. Austin about a week and a half ago. He mentioned immediately how remorseful he was over what he did, that he had let his anger get the control of him. Thankfully, we got this set as soon as possible. My guess is that he's been in custody for 28 days since March 13th. And has to get credit for that time. He understands he'll have a 6-month underlying sentence, that he needs to pay costs and restitution. Although I leave it to the court what costs he needs to pay. I don't know that he is presently working. So I asked the court to infer or ask about that. Everything else was done in a quick fashion, which is good to get him out as soon as possible. I would assume he'll be on court services probation. And Andrew County was kind enough to get the paperwork settled for me when he got shipped. So I'm just making a comment that it's good that everybody was on their game and got this accomplished before a month went by. I have nothing else.
All right. Mr. Austin, now's your opportunity to tell me anything you want me to know in mitigation of your sentence today.
Thing I'd like to say is I'm truly sorry for what I did, and I just never let my anger get the best of me like I did. Learned to control it a lot better being where I'm at.
Good. All right. Well, I appreciate that. And it does sound like it was a bad day and you let it get away from you. I think this is a fair resolution, and I appreciate your sentiments about it, your acceptance of your responsibility, and determination not to let it happen again. So I'm going to follow the plea agreement here. I'm going to give you a 6-month underlying jail sentence. You will be granted probation for a period of 12 months to court services. You'll be credited for all the days that you've already done. You're ordered to pay restitution in the amount of $371.45. Are you, I know Mr. Crawford says you're not currently employed. Is there any reason that you can't get employment, or are you disabled or anything?
No, sir, I am actually still employed. My job still has me employed.
Good
So
deal.
when I get out of here, I'll be at work tomorrow morning.
All right. I'm going to assess the misdemeanor court costs and supervision fees as well. If I ordered you, Mr. Austin, once you get out, to pay at a rate of, let's say, $50 a month, that should get you paid off before your probation is over. Would that be an undue hardship for you?
No, we're not.
Okay, that will be the court's order. All right, I have already prepared the release. I will send that over to the jail. Here's the deal, Mr. Austin. Unfortunately, Andrew County can't just let you go. They have to have Wyandotte County come pick you up, and then you get released from back here. So I'm hoping that would be today, but I can't guarantee you that. I will sign you. I've already signed your order of release, and I will send it to everybody today. Do you know how to get a hold of court services?
Isn't that contacting Christy Hill?
No, she's the court clerk. We're going to adjourn, and I'm going to stop the live